can go ahead and start. Okay. So trial and sentencing. We're getting into the fun stuff. Already asked that. All right. So remember, next Wednesday is the review session, and next Friday is the next exam. Sometimes I lose track of this because Dr. Head says every week's an exam, but I think this one's for real. Anyway, so let's talk about the general process from jury selection all the way to deliberation. So what's the first thing that happens as far as jury duty goes? You get randomly selected. Where do they get your name from?
Voter registration.
Okay, voter registration is one of them. What's the other big one? Driver's license registration. So if you're registered to vote or you have a driver's license, your name's in the drawing to be on the jury. Some places used to, I don't think they still do, but they used to draw from welfare recipient records, which was kind of controversial. But yeah, pretty much anything that gives the government your name. Right, so what happens if you ignore the jury duty summons? Like you get it in the mail and you're just like, no, you throw it away and just walk away. Huh? Yes. The level of punishment kind of determines where you're at, but you can be, there could be a warrant for your arrest for contempt of court if you don't go to jury duty. Now, there are lots of easy ways to get out of jury duty once you're there, but don't throw it away and don't ignore it because you're just going to cause yourself a lot of headaches. Sometimes people will not even realize they got a jury duty summons, like somebody else got their mail and like threw it away or it got lost, and they only learn when they get pulled over for something else, and the cop's like, you know, you've got a warrant on your arrest since a warrant out for you since like last year. You're just like, what? But yeah, always respond to the jury duty summons. Have any of you ever been summoned for a jury? No. So when you're summoned, some of the ways you can get out of it, you can either get it postponed, like if your jury duty coincides with a wedding or finals week, or you have a medical procedure or something understandable. Sometimes they'll postpone it for like a vacation, but there's a lot of times they won't. But there have been people who have had like really expensive like flights to Hawaii that have had to stay home and go to jury duty. So yeah. You can also get it just canceled or postponed or canceled altogether. And if all that fails, there's still some ways we'll get into here in a minute. But yeah, so the jury's been selected. First thing that happens at trial, opening arguments. It's pretty self-explanatory what those are. Anybody not know what opening arguments are? Right. Then you've got the presentation of evidence by the state, followed by the presentation of evidence by the defense in a rebuttal of the state trying to prove the accused innocence. Then closing arguments, once again, self-explanatory. Then the judge hands it to the jury, and the jury then deliberates, and whatever they decide becomes the verdict. Any questions about that? Let's talk about direct versus cross-examination. Direct examination is conducted by the side who called the witness, and when the opposite side questions that same witness, it becomes cross-examination. So imagine I'm the lawyer, and I've called this backpack as my witness. When I ask questions to this witness, what is that? Okay, that's direct examination. The lawyer from the other side comes and asks questions, that becomes cross-examination. All right. Fact versus law. This one might get a little confusing. The jury answers questions of fact, and and the judge answers questions of law. Does anybody know what this means? Got an example coming up that'll help explain this. So as Dr. Head explained, someone can factually commit a crime, meaning that the jury finds them factually guilty, and at the same time, the judge will find that they legally did not commit the crime. So what's an example of that happening? When can you factually commit a crime and the jury finds you guilty, but you legally didn't commit the crime? Think of not guilty by reason of insanity, things like that. It's like, yes, you factually broke into this house, but you were having a schizophrenic episode or something and you thought the house was on fire and you thought you were saving $1, which is a case that actually happened a few years ago. This guy just broke into these people's house and took their dog, was like holding it in their front yard screaming. And he thought he was rescuing it from a fire. And the dog was really confused. But the dog was okay. I think he ended up paying for their window. But yeah, his heart was in the right place, I guess you'd say. So does that make sense? Fact versus law? All right, jury duty. Let's go into a little bit more detail with that. All right, so we've already gone over jury selection in the very beginning, but so like if you get called for jury duty and then you go to the courthouse, the very first thing you're going to do is, depending on the population or the size of the area you're in, you're going to be in a big room with maybe like 100 to 500 people. This is the jury pool. All these people got called for jury duty. All right? The next thing that's going to happen is the judge is going to draw pretty much a second lottery, and of those 500 people, the judge is going to draw 50 more names. You're going to go into a different room, and you're going to go through a process called voir dire. Like everybody that says it pronounces it a different way. This is how I heard a judge pronounce it when I was in jury duty, so I trust that person's pronunciation. But just look at the spelling, just voir dire. That's all you got to remember for this process. So during voir dire, lawyers from both sides are going to ask questions to the selected jury people to determine if there's any conflicts of interest, if they might be biased in some way, and they're going to weed out all the people they can and narrow it down to the 12 most impartial jurors they can find. Sometimes it's a different number, but most of the time it's 12. So what is like a question that would get somebody removed during voir dire? So like, an example would be, okay, I'll think back to the 2020 election. All right, so someone's yard is completely filled with Trump for president signs, Make America Great Again flags. It's just like Christmas decorations, but all Trump. Someone comes and burns down their house and puts a Biden flag in the yard. Okay, you find the person that did that. Are you going to want a bunch of Trump supporters on that jury? No, it's going to be a conflict of interest. You're going to want to get a balanced jury. So that would be a case where asking someone who they voted for or who they supported in that election would be a voir dire question to get them taken out of the jury. That's like a really obvious example. Other examples would be racial biases, that kind of thing. And some less wild ones would be like if you went to school with one of the defendants, or if they're your ex-husband, anything that would give you a good or a bad feeling toward them, or if you've been the victim of the crime in the past that they're convicted of. Anything that would give you an unfair opinion of the person. So does that make sense to everyone? All right, so a peremptory challenge, that's basically the word for when one side asks this juror a question and they determine that this person would not be a good juror for their case. that they request that person be removed. So that's what that is. All right, and the whole let's pick a jury thing, let's just skip that because we only got 4 people. Any questions about these? All right. Witnesses. What's the difference between a lay witness and an expert witness? Would you prefer one over the other to be representing you?
Yes, probably.
Probably?
The expert one, maybe?
Maybe. Like an expert witness, they don't really have anything to do with the crime necessarily. They weren't there. But if the crime is arson, they may be an expert at arson and they can give expert testimony about what this specific evidence means. And then a lay witness, most of the time that's going to be eyewitnesses, people that were just there and saw what happened. But they're not always eyewitnesses. Sometimes they can be character witnesses. Someone saying that, oh, this person's evil, they used to kill puppies, or the opposite, this person's great, they used to rescue puppies. But most of the time it's going to be an eyewitness is the most common one you're going to see called. So how trustworthy do you think an eyewitness is? Not trustworthy? All right. What color was the hat I had on? Black?
Red.
Red? Who says it was black? One person. Who says it was red? Just one person? Anybody have any other color? Who doesn't even remember me having a hat on? Okay. This works better with more people. All right, so we've got black and red. Or gray. All right. It was brown.
Oh, black, close enough.
Close enough.
Close enough. And the lighting it was black.
And the lighting it looked black.
It's a dark.
A dark color. All right. So do we see why eyewitnesses might not be very trustworthy? Now that was what, like maybe 20 minutes ago? Think about when a trial occurs and it's been over a year since the event. Memories can fade. Kind of going back to that's why there are statutes of limitations. So what about expert witnesses? Can you think of any drawbacks there? So once again, what color was the hat I had on? Who says it was brown? Raise your hand. At 100% saying it was brown? Okay. Why do you think it was brown? Is it because I'm the expert witness up here? I have a position of authority and I told you it was brown? Maybe. Because it was actually red. Oh yeah. There's an example of how an expert witness might not necessarily be a good thing because they can tell the jury what to believe. So they may be more preferable to an eyewitness, but don't bank everything on an expert witness. Okay.
Would an expert witness be called to bias as well?
They would not beforehand, but they might be during cross-examination when the other side looks at them, they'll try to point out any biases. But yeah, like a good example of expert witness BS would be bite mark analysis. Anyone ever watched Forensic Files and seen the bite mark stuff? Well, years later when DNA became more prevalent, like the overwhelming majority of people that were convicted on bite mark evidence were exonerated based on DNA evidence. And looking further back at it, like a lot of the supposed bite marks weren't even bite marks. It was just an expert telling the jury that this is a bite mark and this matches this, and they just kind of took it at face value because he was an expert. That's probably one of the most prevalent examples. There have been a lot of examples of arson investigators and expert witnesses being incorrect, because when you find a house that's burned down and you're an arson investigator, you're looking for an arson, and you might overlook that it was a faulty wire. There have been a lot of cases where arson turned out to be faulty wiring. So, still not perfect. You'll still be skeptical there. So, evidence. Let's talk about these two different pairs here. Real versus demonstrative. Real evidence. These are actual objects or recordings, so it's like directly there. You've got the gun that was used. You've got the knife. You've got the surveillance footage. Then demonstrative evidence. These are objects or recordings that create an image. Like, you don't have the actual evidence, but you've got a good idea of what it was, and you're going to demonstrate it. And a really good case to talk about this would be the ballet case. Has anybody seen or heard about that case that was solved with ballet? So this woman was found dead at the bottom of her staircase, and she had a bunch of blunt force trauma, punctures to her head. Like, from the outside looking in, it looked like she had been beaten up and thrown down the steps, which would have been a murder, right? Okay. The husband had a lot of character witnesses, and everybody was like, there's no way he would have killed his wife. He was the only one in the house, and there was a life insurance thing, which it's always kind of suspicious, but it's not always proof of murder. And so one of the investigators, their daughter, was in a ballet, and he saw the different ballet dancers on the wires, like flying around the stage doing the performance, and he had an idea. And so they went to the crime scene. They made a complete replica mock-up of the staircase that she fell down. They put one of the ballet dancers on top of the staircase with the wire holding her up. She was the same height, build of the wife. And they put chalk along the staircase and along the wall. And they pointed out that the wall and the staircase had a gap about this big. And they showed how she could fall down with the gravity, like slow motion with the wires, how her head could wedge between the wall and the staircase multiple times on the way down and create the exact same puncture wounds that they thought were blunt force from like a weapon. So they proved that all of her injuries were from an accidental fall down the steps. And it turned out, looking back at it, I think she fell over a towel on like the first step and then went down the rest of the way, and her head went into a gap this big between wood and concrete. So, yeah. So that would be an example of which one of these types of evidence. Yeah. Demonstrative, demonstrative, different ways to pronounce it, who cares. But yeah. It wasn't the staircase, it wasn't the victim, but they were demonstrating how it happened. So that would be a really good example of good demonstrative evidence. All right. And going back, like the real evidence, like there was no weapon ever found that would have caused her injuries, so they had no real evidence for that. So that further backed up the demonstrative evidence. Right. Direct versus circumstantial. So direct from eyewitness accounts, and then circumstantial is basically inferred. Like, think about this, like there's a hit and run accident, and the person that did the hit and run was driving a just like hot pink Jeep Cherokee. Very unusual and rare car, all right? And somebody was there and witnessed it and took pictures, and they have pictures of you in the Jeep as it's driving away, and they've got your license plate. So would that be direct or circumstantial? Direct, because they know that is the Jeep. It's you in the Jeep, they know that is 100% your Jeep. Right, now imagine there was no witness, there's no pictures or anything, but the cops find you and you have a hot pink Jeep Cherokee, and you drive that route at the same time every day that the accident happened. That would be circumstantial evidence. Like, they can't prove that it was you that did it, but there's a lot of evidence there that says it was probably you. And usually it's hard to get a conviction on circumstantial evidence unless you've got a lot of it. Does that make sense? Okay. So who knows what hearsay is? And why is it not allowed in court? Imagine you're on trial for murder and I'm a witness on the stand, and the prosecution asks me, do you think that this person killed this person? And I'm like, well, I don't know, but this friend I have says he saw him do it. That would be hearsay, and that's not admissible in court. And that's when you'll hear in all the dramas and courtroom video the lawyers saying objection hearsay, because that happens a lot. And the reason that's not admissible in court mainly is because you can't cross-examine hearsay, because you're drawing testimony from secondhand from a person that's not there. All clear on hearsay? So jury problems, one of the big ones would be nullification. This one's confusing sometimes. Think back to the fact versus law thing. Nullification is basically when the jury doesn't deal with facts, they decide to take like the law into their own hands and they make a decision against real evidence. So it's where they will technically agree that yes, this person killed this person, but for whatever reason they all think that that person deserved to die, so they're going to say innocent. And if that's discovered, then the jury is nullified, and that's grounds for a retrial. And it can happen the other way around too. Does it make sense what nullification is? So the jury no longer decides that facts are their thing and that they're going to go with the law into their own hands. Do you have your hand up? Oh, okay. Okay, removal. There's a current event related to this. Even after voir dire, you can still be removed as a jury member. Anybody been following the Rittenhouse trial? One of the jury members made a racist joke to one of the, I think one of the security officers at the courtroom, and pretty much immediately got pulled from the jury. So you can be removed even after voir dire. And in some cases, even after the trial's over, if something like that is found where you shouldn't have been on the jury, that would be grounds to get a case appealed and retried as well. Jury problems come up a lot in appeals.
The jury gets kicked out after that, the door closed.
Yeah, I forgot to mention that. Yeah, you've got alternates. So the numbers vary, but say you've got 12 jurors and they'll pick like 4 alternates. And the 4 alternates will be in the courtroom watching everything unfold, just like the regular jury members, but they don't really vote near the end. They're just there to replace if anybody gets removed or dies or whatever. So you've got 4 backup jurors. So that's what happens there. At the writ of habeas corpus, you've probably all heard this a lot of times but never knew what it meant. So first, this is kind of cool. What does habeas corpus mean in Latin? It means show me the body. This refers to the process of contesting one's imprisonment until sufficient evidence can be shown that you committed the crime. So basically you're going to the judge and saying, I don't agree that I should be held for this crime right now because you don't have any evidence. And going back to the Latin, like you say I committed a murder, show me the body or let me go. Because if you don't have a body, there's not enough evidence to hold me. Okay. Sentencing, now we're getting into the punishment philosophies phase here. And there are 5 major punishment philosophies that we're going to talk about. the four kind of older ones, let's go over those. So the retribution philosophy of punishment, who knows what that is? Get your hand up.
Is that the one where it's like an eye for an eye?
Yeah. Basically just getting revenge for the crime that was committed. It's retribution. The contemporary examples would be the death penalty for murders. It's kind of an eye for an eye. But the main goal is to just get revenge, pretty much. Right? What about the deterrence philosophy? Under this philosophy, what's the main purpose of punishment? Yes, to deter other people from committing crime. I don't know if Dr. Head's going to go over this or not, but within deterrence, there's this concept called the hedonistic calculus, and it's where you calculate the reward for a crime in order to determine a punishment that would make the reward not worth it. Like an example would be, if robbing a bank, if the only punishment you got was a $1,000 fine, then it would be worth it to rob a bank, as long as you got more than $1,000. So you've got to make the punishment worse so that it's not worth whatever you got from robbing the bank. And that would help deter future people from doing it because the crime's not worth the time. All right, what about rehabilitation? This one's kind of easy. Under this philosophy, the purpose of punishment should be to rehabilitate the offender back into society as a functioning member. And incapacitation, what does this philosophy say that punishment should do? Pretty much with incapacitation, it's like, think of the old saying, lock them up and throw away the key. Like if you're a bad person, we're just going to get you off the streets so that society's safer. That would be the incapacitation philosophy. Because you're incapacitated, being locked up, so you can't commit any more crimes. Right. So going on to the big one, restorative justice. What is this philosophy of punishment? This one's a little more complicated. This puts the focus on the needs of the victim, and the punishment is agreed upon between the victim and the offender. So more focus is put on what the victim should think happens, and the role of the state and the judge is basically just to facilitate this process under this philosophy. That would be restorative justice. So some variations of sentencing. Indeterminate, which would be something like 20 years to life, like 5 to 10 years. It's not a solid amount. Like you're going to be there for, like in this case, you'll be there for 20 years. Then afterwards, you can go up for parole, and the judge or whatever could either accept or deny. So you can technically get out at any time after this, but it's not guaranteed. Charles Manson was up for parole for years and years and years, but never got it. Right? And then a determinate sentence is just a strict length. Like you get 20 years for this crime, no less, no more. 20 years from now, you're going to be set free. Unless you do something else in prison to get you another sentence, but that's a different story. Okay. Now let's talk about consecutive versus concurrent. This is the only time we're going to do any math, but it's like really simple, and I made it round numbers so it's easy. So if you were sentenced and you got 3 sentences of 10 years each, would you want those to be consecutive or concurrent? Concurrent? Everybody agree concurrent? Yeah. Because if they're concurrent, they overlap with each other. So consecutive sentences, these are all served one after the other, so they're like stacked on top of each other. But if they're concurrent, they're all served at the same time. I've got an example. I've got this written down. Alright, so if you got 2 sentences of 20 years and 1 sentence of 10 years, if these are consecutive, how long will you be in prison? 50 years? Does anybody say anything other than 50? Nope. Consecutively, you'd be in prison for 50 years. Now, if these are concurrent, how long would you be in prison? 20. Yeah. Because the 2 20s are going to overlap with each other, and the 10 is going to be in there with the 20s. Are we all good on these two? All right, let's watch a sentencing. We're going to see if anybody can count up how many years this guy gets. Keep in mind, these are all consecutive. I'm going to close the door because this gets a little raunchy. Has anyone ever heard of Daniel Holtzclaw? He was the police officer that pulled over and sexually assaulted women a lot and finally got caught. And procuring lewd exhibition, this is a crime that is getting more common, but basically this just means forcing someone to expose themselves to you sexually. So in his case, it was, if you lift your shirt for me, I won't give you a speeding ticket. He was like bribing women to expose themselves. And this is actually a charge that's getting a little more common now. Can anyone think of another example of that? Catfishing someone to get their nudes? That would be procuring lewd exhibition. But yeah, so let's watch this sentencing. If you got a laptop or a phone or whatever, let's count up and see how long he gets. That's him.
Thank you. You can be seated. All right, ladies and gentlemen, let me first make an announcement that we have to have order in this courtroom. There can be no outbursts. There can be no disruptions. If anyone gets out of order, you'll be taken into custody immediately, removed from the courtroom. With that, has this jury reached a verdict? All right, would you hand the verdict forms to my bailiff?
Look at this stack of forms. Now he's going to sift through them. Still doing it.
All right, verdict seems to be in proper order.
Okay.
This is in the District Court of Oklahoma County, State of Oklahoma, the State of Oklahoma versus Daniel K. Holtzclaw, case number CF 2014-5869. Verdict, count 1, sexual battery. We, the jury and panel, is sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of sexual battery and set punishment to 8 years. Count 2, procuring lewd exhibition. Not guilty of the crime of procuring lewd exhibition. Count 3, burglary in the first degree. Defendant is not guilty of the crime of burglary in the first degree.
All right, so you're going to hear the same charges over and over and over again. That's because these are like 13 different women that he did this to. So that's why there's multiples here.
Nor lesser included. Count 4, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 5, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 6, defendant is not guilty of the crime of stalking. Count 7, defendant is not guilty of the crime of sexual battery. Count 8, defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 20 years. Count 9, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 10, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 11, rape in the first degree. the defendant is guilty of the crime of rape in the first degree and punishment is set at 30 years. Count 12, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 13, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 14, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 15, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition and punishment is set at 5 years. Count 16, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy and punishment is set at 16 years. Count 17, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 18, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 19, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 20, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 21, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 22, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 23, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 24, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 25, rape in the second degree by instrumentation. Defendant is not guilty of the crime of rape in the second degree. Count 26, indecent exposure. Defendant is not guilty of the crime of indecent exposure. Count 27, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy and punishment is set at 16 years. Count 28, rape in the first degree. Defendant is guilty of the crime of rape in the first degree and punishment is set at 30 years. Count 29, rape in the first degree. Defendant is guilty of the crime of rape in the first degree and punishment is set at 30 years. Count 30, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 31, rape in the second degree by instrumentation. Defendant is guilty of the crime of rape in the second degree and punishment is set at 12 years. Count 32, rape in the first degree. Defendant is guilty of the crime of rape in the first degree and punishment is set at 30 years. Count 33, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 34, sexual battery. Defendant is guilty of the crime of sexual battery and punishment is set at 8 years. Count 35, defendant procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 36, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Let me ask the jury, is this your verdict, so say you all? Counsel, would you like to examine the verdict forms?
Could you imagine being on that jury? It took them 4 days to go through all that.
260.
Yeah,
Yep, he got 263 years. So that's a lot. But it's not the biggest ever. Anybody remember Ariel Castro? The guy that held the women captive in his home for years? He got like almost 1,500, I think. Yeah, you could get pretty high up there in the numbers with these. So any questions on that?
Charles Scott Robinson got 30,000
Oh, really?
in 1994.
That's a lot. What did he do? Was it like murder? A lot of murders?
Rapist.
Oh. do it.
5,000 years in prison for making 6 pounds of it.
Huh. He's not getting out. Speaking of like,
Against children.
oh, yeah. I'm sure that has something to do with the severity of the sentence. Speaking of like murderers and rapists and stuff, was anybody else disappointed when the Zodiac thing was crap? Like they said they found the Zodiac, but it turned out they were just full of crap.
It's still Ted Cruz.
It's still Ted Cruz. Wasn't he like 3 years old?
So he claims.
So he claimed, yeah. He's immortal. I love those Ted Cruz ate my son bumper stickers. Like I just die laughing when I see those on the road. Anyway, so additional kinds of punishment. Oh, also back to what we just watched. I know that we talked about how the jury deals with fact and the judge deals with law. So you might be wondering why the jury was deciding sentences. Well, beforehand, like all the sentences that are available, the judge will tell them the recommended sentence for that charge, so that if they find them guilty, that's the sentence they get. So it was still the judge's input there. Does that make sense? The jury wasn't just saying, we're going to give you this. But yeah. So let's look at additional kinds of punishments. So can anyone think of additional punishments aside from going to prison or jail? Community service is one. Probation.
House arrest.
House arrest. Fines. You guys are just reading the next slide. It's pretty good. Both other sections couldn't name one, but anyway. Public shaming, we'll go over that one. Yeah, community service is the most common one, which is weird because I forgot to put it on here. But, so anyone think of, has anybody ever gotten community service or known anybody who did? What did you do or what did they do as community service? You don't remember? Do you remember? No?
I think they were like trash outside houses.
Yeah, most of the time when you think of community service, you think of like trash collection or recycling, sorting, but it's not always that. Like you can also be sentenced to work a certain amount of shifts at a Goodwill. You can be given janitorial work at a hospital. I had a friend who got like, I think 20 hours of community service and at the, like the animal shelter, and they just walked dogs, which sounded more like a reward to me, but that would be community service. But yeah, probation, we all know what probation is, right? So what is suspended sentencing? Very similar to probation, but it's a little more severe. So like, I'm the judge, I'm gonna give you 20 years in prison, but suspended for 10 years. Which means that you're free to go, and as long as you behave and don't commit any more crimes for the next 10 years, then that's gonna get wiped. But if you commit a crime, especially one related to the one you were already in trouble for, then you get that 20 years on top of the whatever you do again. So it's like they're floating this 20 years on top of you to make you behave. That's like a probation on steroids, kind of. Right. House arrest, just think of Martha Stewart. Offender registration, sex offender registration, probably the most obvious one there. Has anyone ever downloaded that app to show the map of it? At the gas station I worked at in Kentucky, like we downloaded that app one time, and like the whole area we were in just lit up like a Christmas tree. It was kind of scary, but yeah. But then you got to think, like, not all sex offenders are like the same. Like a lot of them are on there for like they were drunk and they peed too close to a school. They got on there for like 2 years for indecent exposure next to a school. So there's like a sliding scale there. But anyway, still not a good list to be on. Stay inside if you get drunk. Fines, we know what that is. Who knows what time served is? This is when, like, let's say you didn't make bail and you're sitting in jail for 2 years awaiting trial. At the trial, you're found guilty, but they sentence you to time served, meaning that The time you've already served is your sentence, so you're free to go. So it's like a win-lose. You're guilty, but you don't get any more jail time. All right, public shaming is one of my favorites. This was very common back in like a few hundred years ago, kind of fell out of favor, and it's getting more common now. Remember all the things like the people that would be put in like the stocks and bonds on the side of the courthouse, and there would be a sign above them saying what they did, and you would like throw rotten food at them. Like the Scarlet Letter is a good example. Has anyone heard of like contemporary examples of this? It's becoming much more common, and it was kind of a solution to prison overcrowding. Judges were looking for more creative ways to punish like low-level crimes. So you get things like this. Somebody shoplifted from Walmart, you've got to stand in front of Walmart with that sign for like 8 hours a day for the next 7 days. Or this lady who passed a stopped school bus on the sidewalk, says only an idiot would drive on the sidewalk to avoid a school bus. She had to stand where she committed the crime. And then this guy who didn't show up to court. I think it's fun to ask, okay, if you shoplifted at Walmart, would you rather have a week in jail or a week spending pretty much 40 hours standing outside the front door wearing this in your home community? Everybody wants jail? Yeah. Huh?
I mean, free food.
Yeah. Alright. Well, I've heard it's not always free. Like sometimes don't you get like bills when you get out? But I mean, what are they gonna do if you don't pay that? Put you back in there to rack up more bills? Anyway. So yeah, I love public shaming. And that's it for this week. Remember, Wednesday is the review session, and then Friday's the exam.